At the Corporate Counsel Exchange, you led a session on the new age of dispute prevention and risk management. So can you briefly explain what you covered in that session?
Yes, it seemed to me that actually in the last 27 years of me practicing in the litigation world, it's changed so dramatically, and I think it's got even bigger changes coming ahead. And I say that because when I first started off as a litigation lawyer, litigation was very much a practice of its own. Today, we very rarely see law firms having litigation departments. They have dispute resolution departments. And actually, when you talk to general counsel, even that is something they're trying to veer away from. So for us litigators, if we're trying to get closer to people that are giving us the work, we have to think much more around dispute prevention and conflict management. And so that's very much the theme I wanted to bring across, that if you are a creative lawyer, if you are constructive in the advice you're giving, you're trying to move yourself up the food chain, talking to the in-house counsel and hopefully the business at a much earlier stage, trying to anticipate risks and heading them off at the pass, if you like.
How do you think general counsel can proactively partner with the business to identify conflict management protocols?
Well, one of the things that we were talking about today in the brainweave was that in King Spalding we've got a couple of tools that we've used that we use when we're talking to in-house counsel ourselves. But the more I thought about it when I was preparing for the brainweave, the more I thought that they were very useful tools for in-house counsel themselves to use, because often they're very big law departments in the companies themselves. And one of them was the risk management curve that I talked around, which was trying to map the legal risks around what the corporates are trying to achieve in their business objectives. So that if they've got a new product launch or they're going into a new geographical territory, you as a lawyer, rather than just giving very 2D legal advice, you're actually mapping out the legal risks that you know are inherent in that strategy. And that gets you closer to the business. And if you work with external counsel, then you're able to give a legal risk audit and map that in some privilege so that it's a document that can be a Watson or warning to the business that if they want to do what they're planning to do, they need to be able to manage or try to minimise some of the legal risks attached to that. So if you start to do that and you get to know the business early, before disputes have happened or issues are arising, you find yourself getting that trusted advisor role that we long time ago all used to have as lawyers. Many boards had lawyers sitting at the table, at the board table, advising the board in terms of their strategy. I think unfortunately now a lot of the litigators have lost that role. They've gone back into the law firms, they're sitting in the litigation department, and they're brought in far too late. And that's the fault of the litigation lawyer if they're not getting closer to the business through the in-house lawyer and being seen as a constructive risk manager as opposed to someone who you run to when things have already gone wrong.
What trends are you now seeing in dispute resolution, and what types of tools and techniques are general counsel now looking for?
I think it's been interesting. In the last 5 or 6 years, there's been an awful lot of talk around cost cutting and trying to get more for less in terms of legal services. But I've seen a real sophistication in the general counsel over the last 5 to 10 years. People are recruiting really top quality lawyers in-house. They're paying much better, and therefore it's a really viable career choice for lawyers. And so we're losing a lot of really good talent in-house. And at King Spalding, we're very interested in seeing why that's happening, but it also means that you've got much more appreciation of what the general counsel's role is and what the external counsel's role is. And I think this partnering between the two and making sure you get value for money and making sure you understand that the outside counsel is also there in a business trying to make a business and not therefore trying to squeeze every bit of margin out of a law firm, is making it a much more rewarding relationship for law firms and for general counsel. So there's a much greater sophistication, a better approach to getting value for money as opposed to something for nothing. And that's, I think, led to a better attitude and a better behaviour pattern from law firms in return, in understanding that if you want to have work from a corporate for longer, you have to invest in the relationship, and that therefore means you have to give value back. You have to think about regular training, you have to think about the risk audit that may be a free investment of time to get to know the way the business works. And if you do that, the payback is a long-term relationship, an investment in a relationship that's actually much more rewarding. It's a nicer job to have.
In the US and the UK, we talk about litigation lawyers, whereas in the rest of Europe, they simply refer to as lawyers. Why do you think that is?
I think this is fascinating, and it's interesting, isn't it? Because there might be a tendency for the English lawyer or the US lawyer to think that the way we do it is the way that everyone should do it. But actually, my experience of working in a European law firm, and indeed working at King Spalding, an international law firm, is that we can learn an awful lot from our European counterparts, because they look after their clients in good and in ill. They've drafted the contract clause and then they sort out the problem if the problem arises. And I can see a real benefit in that. Again, it goes back to this trusted advisor. I think sometimes the law firm's infrastructure and having a litigation department and a commercial department means that sometimes you have to wait in silos until your particular skills base is being called upon. Whereas actually, if you think about it, when you're putting a contract together, the commercial guy is putting it together with his mindset, but a litigator could look at those clauses and say, well, what if this were to happen? And what if that were to happen? And if we were to put in a slightly different clause, are we going to at least be thinking about minimising some risks? So I would like to think that litigation lawyers and non-contentious lawyers work together better if they are there at the outset thinking around risk management.
So what is the General Counsel actually looking for in an advisor today?
I think today general counsels that I work with will say to me, Jane, we need you to be available to us when we need you. We need to have advice that's very pragmatic and is very constructive and is very relevant to the business questions that the business are asking us. So I think they really want partners. They want us to in a way, to make them look good. They're terribly busy. You watch the general counsel and you know that when they have their client come to the door, he's standing in the door of his room and they have to answer the question. It could be as varied as 10 different questions in the same day of different parts of the business, different geographical areas. And so they need to look to their external law firm to be very, very proactive, to be trying to anticipate the sort of issues that they're going to have to be dealing with and to be able to react very quickly to them when they need those kind of answers.
So are law firms actually set up correctly? Now the general counsels have more purchasing power. Do you think the law firms need to change their structure in order to meet the general counsel's needs?
I think they should. I mean, I think it's really interesting because now, as you say, the tide is changing and in-house counsel have huge amounts of purchasing power. The world is very, very competitive. Law firms have to be on their toes to make sure they not only win the work but keep the work. And that's a good thing. That's a good thing for the industry. It's a good thing for us. What I think that does mean is that law firms need to think about how they structure themselves. And so you will see, and we certainly at King Spalding do this, we have all client teams. And the client teams would be across all the different infrastructure groups that we have. So it could be litigation or employment or property or commercial, but all of us are focused on the client's business. It might be the client's business or it might be a sector. So for us, it would be energy or pharma. We will have teams that really know both the industry as well as the legal risks that sit with it. And I think that we have to adapt ourselves to the way that the corporates work and not the other way around, where they have to pick and choose from the different groups that we happen to have structured ourselves in the historic past.